So, Mr. Allen, we had started to do probable cause, but I wanted to wait. No, over there. Um, so that we get your perspective on it. So, all right. So you stand charged with criminal trespass. You're facing up to 6 months in jail. We're going to do probable cause again now that your lawyer's here. Okay, please.
On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, who both stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant, and the complainant and witness pointed to him, stating that it was indeed the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Is the witness.
So let me see, Your Honor.
I mean, he had authority to be there, and I know that you can revoke that, when you overstay your welcome.
Yes, right? Judge. So the complainant is the office manager and the witness is security guard.
Okay. Did you want to add anything?
Well, Judge, my issue is he's been at that facility for years, and he has 3 separate doctors within the same UT facility, and he was there for his doctor's appointment. And there's some contention as far as whether he was asked to leave or not, considering that doctor's appointments take months to schedule in advance, sometimes up to 6 months. So I don't believe that if he had a right to be able to see the doctor, I don't believe that a person that's unidentified, the original complainant, I think her name was.
Right here is where things get real. Criminal trespass might sound minor, but in Texas, it can mean up to 6 months behind bars. And this is only the first domino. The court is about to decide whether this case even moves forward, and that decision hinges on one key phrase you're about to hear a lot: probable cause. That's a much lower bar than guilt, but once it's cleared, the machine starts rolling.
Amy should be able to come in to tell him to leave, if in fact she even told him to leave. So I think there's...
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yes, Judge. And then he still refused to leave once security got involved. And we contacted the complainant as well, and to add...
You have spoken to the complainant?
Yes.
Oh, okay, tell me.
And the complainant said that the defendant was sitting in the lobby after his visit, and the reason he was asked to leave is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had concluded, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause to go forward now. Did you speak to them? Tell me.
They said he's no longer a patient.
No longer a patient. Okay. So you can't go back there. Okay, Mr. Proler, you must find a doctor, but it appears that they don't want you to go there anymore at this particular doctor's office. Okay.
Well, Judge, not add, like I mentioned, he has 3 separate doctors within the same building. So is the court asking him to stay away from that particular single
Correct.
office?
Right.
Okay.
So if you have business in another part of the building, you can go. Just don't go back to this office, because the chances are, if you go back there, they're probably going to call the police and they're going to charge you with another trespass. So don't go back over there, because they've warned you not.
This is a classic trespass gray area. You don't need a police officer to tell you to leave. Anyone with authority over the property can revoke permission. The moment that happens, staying turns from awkward to arrestable. The defense is betting on confusion. The prosecution is betting on clarity. Guess which one usually wins?
To go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But okay, so then just stay away from wherever that office is, and you can use the other 2 places. But I'm not barring you from the building, just from going back to that particular office. What is the confusion?
Oh, I want to bring to your attention this alleged other incident.
Doesn't matter.
Yeah.
Okay,
Yeah.
sorry.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
It's a UT Physicians Bel Air station, so I don't know how they organize that office there. So I think just one system. It's not necessarily separate offices, like different. Maybe just be
If
one.
he has two other doctors that he sees there,
And that's part of the issue because, again, it's part of the same system. So I don't know. They do have multiple doctors there, but it would be at the same facility. And they told us that he's no longer a patient at the facility. So presumably that means no doctors there, but we could clarify if you would
I
like.
think you need to.
Yes.
You definitely need to, because this could be a potential problem.
Yes, we can
And
certainly
he's saying
clarify.
he's still seeing two other doctors
Yes.
there. They may not know of the other two doctors. You want to do that real quick to see, real quick? Can you give me 5-10 minutes? Let me see. So, hey, Alex,
Yes, sir.
also see, are there different, in most like buildings, there's suite 101, 102, 201, 202. How do they do it over there?
Yes,
Is it
Judge.
by like
We'll see how they
an
organize.
office suite, and then
Yes, Judge.
is it possible that he can see the other two?
Yes,
And then, okay, yeah.
So, I was doing my due diligence on my end. And
Great.
I made contact with, another provider in the facility. He is a current patient there at this time.
Right.
So I just wanted to verify on our side.
Alex, did you hear this?
Oh, I apologize.
So-
And Will, because this is your deal as well. So they've verified that council has verified that he's seeing another doctor at that facility.
Okay.
So what we'll do, like I said, you are on notice of what you can and can't do. We don't want you to go to the complaining witnesses in this over there, wherever they may be, wherever their office is. Do you understand? You can see your doctor if you have another doctor there, but I don't want you to have contact with these people here.
If I understand you correctly, Judge, I can continue doctor's appointments there, but don't.
How is the facility divided up?
This building is not the best building to have doctors in, to be perfectly honest with you. But you get off the elevators or stairwell, whatever route you choose, and it kind of wings off. Let's say.
Is there a possibility that you're going to run into these people?
The same floor, separate floors.
Yeah, I'm sorry. Under what circumstances, Judge?
I don't want you to run into these people.
Is there,
And we say these people.
is there a way you can get to your other doctors without going to the cardiologist? In front of that building, in front of that suite?
Oh, I think I understand what you're saying.
Is there a different way you can go around?
I mean, it shouldn't be this difficult.
I know. I agree.
I don't understand why what is the doctor's name, or what is the facility? Who are we talking
So
about
we're
here?
talking about an Amy Whitetree. So she's the office manager for whatever department she's in.
I don't want you to have contact with these people.
Can I tell you something, Judge? I don't know. I mean, I now know who she is, but she did not identify herself at the date on the date of the incident.
Okay.
And she didn't have a UT badge or anything. Some woman came and talked with me. Now I understand she has a name. I sure would like to hear the complaint of the name, if that's okay with you all.
I don't want any more issues. If they call me and they say that you're becoming a disturbance there, I'm going to revoke your bond, and I'm going to.
This is the court saying, we're done debating. The judge isn't banning him from the building, just this office. That distinction matters legally, but practically, it's a tightrope. One wrong turn, one accidental encounter, and suddenly you're not explaining, you're defending.
put you in jail. Do you understand?
I don't blame you.
I don't want to make this any more difficult than it is. You know what you can, you know what you can't do. The condition of your bond is you're not to have any contact with the complaining witnesses in this case, not to go where they work. They don't want you to go where they work. That's it. If we get wind that that there's any issues, only one thing's going to happen. You know what you can and can't do. I just don't know how else to explain it.
I
But
understand.
Sure, that's
Yeah.
pretty clear. And that'll be the only condition, Judge. This is his first contact with law enforcement. He's a retired captain of the Houston Fire Department for 22 years.
Okay.
So he's not gonna be in any trouble whatsoever. It's still misunderstanding.
yeah, if it gets to the point where you may need to find another doctor because it becomes impossible for you not to run into them, but you're the one that's on bond for this case, right? We'll give you as much as we can, but I just don't want any more problems. I don't want them to live in fear. I don't want them to live in, oh my God, is he going to come back? No, we've told you what the expectations are. That's it. Okay. If you have any questions, you've got a lawyer. He can help you out. If there are any issues that arise in the future, you can always come back here. We have an open door policy. So we're always here for you, whatever you may need. Don't take matters into your own hands and just be good. That's it. We'll have conditions for you to sign after you're done with that. Then you're on your way.
Thinking appearances are way for.
Correct. So
thank you.
because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court here, but you must stay in touch with counsel and he will tell you when you have to come back to court.
Sure.
If he tells me that you've gone AWOL and he can't get a hold of you, you're not answering phone calls or text messages, that's when we revoke bonds. You pick up a new case, I'm going to revoke the bond. Okay? All right, guys. All right. So they're going to have it filed, let me sign it, and then you're on your way. Okay. Of course. Thanks.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received the letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens.
When a judge says, I will revoke your bond, that's not courtroom theater. Bond is a privilege, not a right. Violate it, and you don't get another warning, you get handcuffs. This is the justice system's version of a final yellow light.
Okay, thank you.
Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
No, it's not. She at home.
Did you come with mom today?
No, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But How on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR moment. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond though, Judge? Because I believe the bond's at.
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're setting the bonds ultimate.
I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson then. All right, gentlemen, both of you have picked up criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer. It looks like both of you, Mr. Benson, are charged with theft, and you're facing up to 6 months in jail and or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. The agreement you have worked out, Mr. Benson, is 22 days in jail, credit for the 22 days so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you will be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, you are with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You can never take it off. And from now on, you're facing a minimum of 30 days in jail. Do you understand? Is this what both of you want to do?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. It will go on your record. It'll stay there forever. How do you plead to the offense, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it. And Mr. Lowry, how do you plead to the offense? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, if any enhancements, just abandon it.
On the.
Oh, do we need to do it on the
Well, there's
theft?
one with the second conviction. on
Got it.
theft.
All right. So, Mr. Benson, you have a prior theft from 2019. Is this true?
Yes, sir.
Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a pack of gum, a big pack of candy, be careful. You could be facing some serious time next time. You understand? Okay. So, true to the friends. We'll abandon the other one. All right. Good luck, gentlemen. Thanks.
All right, gentlemen.
Oh, and Mr. Benson, your second case will be dismissed. I didn't realize you had it. Oh,
I was told I needed to approach on Mr. McCullum. He's not here today.
we have quite the, did you represent him before?
No.
Okay, we have quite the history with this gentleman
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think did it get dismissed or did he plead? I
I
don't
think
know.
one of them pled and the other one got dismissed.
So he's now picked up a new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten letters, or I'm sorry, emails stating that because of this case, I think he like broke his leg in half, is what he's saying. He broke his knees, tibia, fibia. I don't know.
Okay.
He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be, but I was going to do probable cause number one to see, was there really an injury that occurred? I don't
It
know.
says he tripped and fell. The officer indicated that he tripped and fell as he was running.
Mind
Yes.
happen, please.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 Westridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant toss an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer wearing full uniform told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff, and the defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time. Is that what that says?
Didn't say anything in the DIMS.
No, and it does not say anything regarding whether he was taken directly to JPC or whether he was taken to the hospital. This is a Houston Police Department case, so we do have the offense report, so I can.
Do you mind looking it up real quick?
Yeah.
Maybe just the DIMS doesn't say it. The emails that we've gotten is saying that he's in such pain and such dire circumstance that he cannot make it to court. But I have quite the history with this gentleman where
Yeah, so he was taken to the hospital due to a leg injury. He was taken in an ambulance.
say that.
Yes, Judge.
okay. So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it, when can we get him here, how, and we'll go from there.
I did see he has felony on the 30th, so I'll see if I can get in contact with him and find out if he's going to come to that, and if so, we'll just do it the same day.
Yeah, I'm okay with that.
Okay.
Okay, great.
Okay, perfect.
That way you can, now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So when you reach out to him,
Communicate
Don't-
or anything.
don't call me, don't email. It's been quite, just please.
Yes, sir.
Yeah, okay.
Were we given, because you said you wanted to think about the hospital.
Okay. I think that's it. I think we're done. What?
We have some plays that are falling wrong.
Oh, on,
Approbation and overstrap. I'm not sure. Garrett is one of them. This is Ray.
yeah, I remember. You said Garrett? I'm on.
Stovall.
I mean, endless.
Yeah.
All right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk, your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences.
Okay.
Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right?
I think there are enhancements.
Okay. All right. All right. Good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
How do you plead to the offense, sir? Guilty or not guilty? All right. I'll find you guilty, sentence you to good luck. Thank you so much, Ray. Hi.
Hi,
Good morning.
Happy New Year.
Happy New Year.
I am approaching this morning on Robert Moore.
War?
Yes, Moore.
More with an M. Okay. Oh, he's not.
Oh, no, that's somebody else. They both have the same last name. Yeah, I have another case that got moved to Friday. Her last name is Moore.
Is this is a new case?
Yes, it is.
16, Your Honor.
You mind bringing him up? Oh, this is the case. Okay. Okay. Right. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle. and the marijuana was weighed and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And Your Honor, if I may, the issue that I have with the PC, so in regards to the speeding allegation, there were two cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD. It's in my backpack. When you search, you're gonna find it. It's gonna be in there. But I purchased it earlier today from a smoke shop, and so when the officer did retrieve them out of the backpack and asked about it, he's like, "Well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that."
What form is this CBD in?
It was like in a little,
Is it?
it was a flower, so.
It is a flower.
Mhm. So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may. So as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're gonna test it. If it tests different, then there we may have an issue. But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's gonna happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's gonna happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right? Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Judge, I have an Anisha White on the docket.
Okay, it's getting up there, but
Yes.
not up there.
So I just asked the state to eval the last time they did. I would like to get a trial date, but.
Of course you can.
Okay, then I'll do that.
Sure. Yeah, just talk to Ramona, whatever you want.
Thank you, Judge. And
of
then
course.
I also have a Coriel Dixon on the docket.
How's Miss Dixon doing?
She's doing well. Judge, she.
Did you finish it yet or what?
No, her last class was on 12/19. Then they took a break and they come back tomorrow. She brought her over the break homework and study guides that she's filled out.
Okay.
So she's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she takes the test, because she took the evaluation test already. Those results aren't back yet because that was right before the break. So we should know in the next couple of days, hopefully.
So let's set it off a week to see, and then we'll go from there. And then, but we're there, we can do just a longer day, huh?
Yep, sounds good. Thank you,
Okay,
Judge.
thanks, bud.
There was a video that's just not on this case.
I know, I saw it. That's why it's. So what, come on up.
Good morning, Judge.
Is he here? Is that him? That's not him, right?
No.
Okay.
My understanding is that he is still home with a sick child. I do have a doctor's note that I showed to the state. I don't know If that's sufficient for the court, then that's.
Okay. Yeah, it's just regular. Okay. Yes, ma'am. You ready? Hey. Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
It's his regular setting.
Okay.
We had accepted the plea offer and we're ready to move forward today before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first, and I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash, and one false move, they're going to file a motion to revoke. And if they prove it to me that you violated this probation, get ready. For you to complete it, what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a third-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harris. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first. So it's a $3,000 fee, but let me ask you this. Is this a 0.15 or above?
To your honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be 0.15.
Okay. You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Kate. All right.
Judge, are you issuing a military license? He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay. Yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay. So if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000 plus the court cost, who's going to pay all? Are you Miss Troyanne Marie Britton?
I am.
Miss Britton, you are charged, I'm sorry, you are wanted out of Georgia, Fulton County, Georgia, specifically for possession of a firearm or knife during a commission or of an attempt to commit. I don't know what, it just ends there.
Felonies, Judge Fletcher.
To commit certain felonies. Your lawyer has asked for me to set you a bond. I don't know. I don't know anything about you. I've never met you before. So I got to see who you are as to see whether I'm going to set you or not. You know, one of the main things is, are you a danger to our community? Number one. Number two, if we set you a bond, are you really going to go back or are you just going to take flight? Those are the things that we're really concerned with here. Amy, tell me about Ms. Britton. Or Katie, or is it you or anyone?
Yes, Judge, I'm here.
Okay.
I would be a little bit concerned, Judge. I am seeing 2 failure to appears already on her criminal history. I see a possession of a pistol by a person under 18.
Wait, what was that?
A possession of a pistol by a person under 18. Interesting charge. And then I see a failure to appear. I see possession of a controlled substance, marijuana charge, willful obstruction of law enforcement officers, and aggravated assault, theft by receiving stolen property, driving without a valid license, another failure to appear.
Is that
so I am a little bit concerned.
That's 4 failure?
No, I'm seeing 2 failure to appear, Judge.
Were they fugitive cases or just open cases elsewhere? And where is all that history from?
So I can't tell, Judge, if it's a fugitive case or not. I see that it's out of Fulton County. Let's see. I see Atlanta Police Department. It looks like most of these are out of Fulton County, Judge.
How long ago are the FTAs? Is it recent or?
So one is from 2023 and the other one is from, trying to look for a date, Judge, is from 2024, from 6/28/2024, it appears.
And I'm assuming that 6/28 one is the one that's holding her right now.
It might be, technically the warrant that we have written down is possession of firearm. So it doesn't specify whether it's a failure to appear warrant
You know when
or
the
not.
hold was placed?
Let's see.
She was booked on our.
It looks like it.
7th.
I'm sorry, it looks like it's from February of 24. Yeah, it doesn't, like I said, it does not specify that it's for the failure to appear.
Judge, so she hasn't been before your court. This is one of those cases where I'm not asking for a PR bond. I'm asking for a bond that would ensure that she turns herself into Fulton County. I've talked to her about your requirements if you were to set a bond, how that affects her, how that affects the bond. She needs to present herself. She's got criminal history, I'll give you that, but she hasn't been before your court before. We're asking for an opportunity for her to go turn herself in. She's willing to do that within 14 days and show proof of that. If she doesn't turn herself in, well, then I got nothing to say, but at this point, it sounds like possession of firearms are most of the cases that she has.
All her cases are dangerous cases. Assault, ag assault, possession of a pistol. Now she's got a pistol case, committing certain felonies. We don't even know what the felonies are. Do you know?
No, Judge, not at this time.
I only heard of
A bunch of FTAs, at least 2 other FTAs. Now we've got a third. What? You really want me to set you a bond? I want hair. Not gonna happen. No, at some point we got to say when. But you know, you've racked up a bunch of criminal history. How old are you? How old is she?
She's, I think she just turned 19.
19 and all this?
Was I right about that, Troy?
Absolutely not. I'm in shock that you're 19. And Katie, how many priors are we talking here? At least like 6, 7, 8?
It appears so, Judge, yes.
No, I'm sorry, but I just, you scared me, Miss Britton. Really, I don't think that I could trust you. I think if I set you a bond, it's something is going to happen, or you're just not going to go back. And I'm sorry, I can't.
Understood, Judge.
Right. The good news is that you've made bond on your other case.